Hello, everyone. Welcome to Behind the Crime Door. I'm Kristin. For those of you that are not familiar with my channel, I cover true crime. Um, Currently, I am focused on the Delphi murders case. And today, what I'm going to do is talk about or go over the defense motion to dismiss that was filed yesterday. Um, they actually have filed this before. And this time they put a ton in this document, and I just can't not talk about it. So I'm going to go over it in a video rather than a live stream. And then I'll talk about it at my live stream later tonight. The defendant's second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory or potentially useful evidence. Comes now the accused, Richard Allen, by and through counsel Andrew Baldwin, and pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution, Article 1, Section 12 of the Indiana Constitution and Indiana Code 35-34-1-4A 11 moves this court to dismiss charges against the accused for destroying or losing exculpatory evidence or potentially useful evidence in violation of the standards set out in Brady versus Maryland 373 U.S. 83, 1963. In support of said motion, the accused states the following. Hang on, guys. This is going to be a long ride. This is 20 pages long. You know, the defense, they're wordy individuals in their motions. They can't just get to the point. So I apologize that this is so long, but it's important. Number one, that on February 7th, 2024, the accused filed his motion to dismiss for destroying exculpatory evidence and memorandum in support of said motion. Number two, in his first motion, the defense detailed how a February 17th, 2017 interview of third-party suspect Brad Holder was destroyed while in the possession of law enforcement, along with multiple days of other interviews. Firstly, let's point out here, Brad Holder was never a suspect. He may very well have been a person of interest in the very beginning, or possibly just someone that they needed to look at simply because of Logan Holder, his son's relationship with Abby Williams. And by the way, just so everybody is clear on this, Abby and Logan Holder did not date. I am so tired of hearing the national media and everybody else say they were dating. She was 13 years old. She was not dating anyone. Lord. Number three, on March 18th, 2024, a hearing was held on said matter. Number four, at the March 18th, 2024 hearing, Steve Mullen, the investigator for the prosecutor's office, testified that other evidence was destroyed in 2017, as well as it was purportedly unintentionally taped over. Number five, furthermore, at said March 18th, 2024 hearing, the defense tendered Mullen's undated reports that purportedly explained how the evidence was destroyed. Now, you notice here that they use the word purportedly because they're not believing what the police are saying here. They are not believing Steve Mullen's account that this evidence was accidentally taped over. The prosecution did not tender these reports to the defense until after the motion to dismiss was filed. Also, said reports were only turned over to the defense after the defense requested those items from the prosecution. How can you turn something over that's not exculpatory evidence in discovery if you don't know about the fact that you want it? So this evidence that they're talking about was not deemed evidence according to law enforcement, because these individuals were looked at and were determined to not be part of this crime. Number 7, on April 2nd, 2024, this court issued its ruling denying the defense motion to dismiss the charges. Number 8, since the time of this court's denial of said motion, the defense has learned of other exculpatory evidence and or potentially useful evidence that the prosecution has not turned over to the defense, is missing, or that the state of Indiana has destroyed. Number 9, just like Allen's first motion to dismiss, the missing destroyed evidence relates to the third-party suspect, Brad Holder. Number 10, Brad Holder's missing phone extraction data. During a recent deposition of Brad Holder, the defense learned that Brad Holder is pretty sure that he turned over his phone to law enforcement on February 17th, 2017. Number 11, the prosecution has not turned over any data extractions, reports, or other evidence from Brad Holder's phone. Number 12, curiously, on the same day and at the same time that Brad Holder believes that he turned his phone over to law enforcement officers, his son Logan Holder also turned over his Logan Holder's phone. 13, the prosecution has turned over the data extracted from Logan Holder's phone, but not any data extracted from Brad Holder's phone. Number 14, while the data from Logan Holder's phone was extracted, law enforcement apparently claimed that they, law enforcement, failed to extract data from Brad Holder's phone, even though both he, Brad, and his son Logan turned over their phones to law enforcement at the same time. 15, Jerry Holman stated under oath at a recent deposition that he believes police just looked through Brad Holder's phone, but encouraged the defense to find out for sure from the FBI. Holman, May 3rd, 2024 deposition, page 6, lines 13 through 15. Number 16, when asked if he, Jerry Holman, would have extracted data from Brad Holder's phone if given the opportunity, Holman was non-committal. Depends on the circumstances, but I think you have to ask the FBI what they did. Holman, May 3rd, 2024 deposition, page 6, lines 22 through 25. 17, finally, after being pushed by the defense, Holman finally conceded that he would have extracted data from Holder's phone if given the opportunity. Holman, May 3rd, 2024, deposition, page 7, lines 8 through 12. Sounds like the FBI was the ones that looked at Brad Holder in the beginning, as they were the ones, it sounds like, who had his phone. So instead of talking to Jerry Holman, it sounds like the defense should be speaking with the FBI. Number 18, the defense finds it highly, highly unlikely that law enforcement would take the time to collect both Brad Holder's phone and Logan Holder's phone, but then choose to only conduct an extraction of Logan Holder's phone, especially when Brad Holder was a suspect at that time, and no evidence provided to the defense suggests law enforcement considered Logan Holder a suspect. First of all, Logan Holder had a relationship online with Abby Williams. There were text messages, I'm sure, at least on his phone between the two. Okay? That in itself would lead law enforcement to want to extract that information. Secondly, Brad Holder was not a suspect at this time, and the defense is simply saying this because they want the public to think exactly what this document is trying to say. That the police had a suspect that they didn't look at closely enough. Brad Holder was not a suspect. He probably was a person of interest simply because he was the father to Logan. They may have looked at his phone, saw that there was no communication at all between the girls or anything else, didn't find anything alarming on his phone, and decided it wasn't necessary to extract. That is my opinion. 19. On February 17th, 2017, documents specifically sought by the defense, Doug Carter's emails with the FBI, provided evidence that A, Brad Holder was a suspect within days of the murder, and certainly on February 17th, 2017, when Holder interviewed at the Delphi police station and turned over his phone to law enforcement. B. State Police Superintendent Doug Carter was aware that Brad Holder was a suspect. C. Even the top FBI agent in Indianapolis, Jay Abbott, was aware that Brad Holder was a suspect on February 17, 2017. D. Logan Holder was not mentioned as a suspect in these emails. Okay, first of all, I do not believe for 1 minute that he was a suspect. He may have been a person of interest that they were looking at because they were looking at a number of people back then. But he was not a suspect who they were going to come out to the public and say was a suspect. 20. And that's important language, you guys. That's just important. So just know they're using that word to inflame the public. 20. This begs the question, why would law enforcement take both Brad Holder's phone and Logan Holder's phone, but only extract data from Logan Holder's phone when he was not a suspect? First of all, again, it would only be common sense that law enforcement would look harder at Logan than they would his father, simply because Logan's the one who had the relationship with one of the girls. Good Lord. 21. Additionally, the defense possesses 101 or 101 phone extractions that law enforcement conducted on a variety of other phones, many of which seemingly have little or nothing to do with the murders. Imagine that. 22. This begs another question. Why would law enforcement take the time to extract data from 101 phones, most of which were not owned by suspects, yet would not extract data from Brad Holder's phone when they had his phone in their hands on February 17th, 2017, and he was a suspect at that time? 23. The defense believes that the above information provides strong circumstantial evidence that law enforcement did extract the data from Brad Holder's phone on February 17th and has not turned it over to the defense. 24. Logic and common sense support this belief. Firmly, there's no common sense among this defense team. 25. If law enforcement failed to extract suspect Brad Holder's phone data while it was in their hands on February 17, 2017, then the only other explanation would be that law enforcement was completely and utterly inept. It couldn't possibly be that Brad Holder was ruled out as having any involvement in the crimes very early on. He was at work. All evidence of Brad Holder's second interview with law enforcement is missing. 26. Additionally, Brad Holder testified in his deposition that in addition to law enforcement's February 17th, 2017 interview, which was reportedly accidentally taped over, that that law enforcement conducted a second interview of Brad Holder sometime later, probably within a year or two of his first interview. And I'm assuming this was when they found out about the Odinism angle, is what I'm thinking myself. Number 27, Holder further testified at his deposition that A, law enforcement conducted this second interview at the Logansport police station. B, the interview took about an hour and a half. C, the interview was likely videotaped in an interview room. And D, the interview involved much questioning about Patrick Westfall. 28, after the deposition, the defense alerted the prosecutor's office that the defense had A, no phone dump extraction evidence from Brad Holder's phone, and B, no evidence whatsoever in the form of video, audio reports, notes, or any other type of evidence of law enforcement's second interview of Brad Holder at the Logansport police station. Number 29, on May 13th, 2024, the prosecution advised the defense by email that they cannot locate an interview of Brad Holder at the Logansport Police Department and have no record of Brad Holder's phone being downloaded. 30. At a recent deposition, when Unified Command's Jerry Holman was asked about how the defense could obtain any information about this second interview, Holman said he had no idea, but encouraged the defense to reach out to the Logansport Police Department to find out. Holman's deposition, page 5, lines 20 through 25, and page 26, lines 1 through 2. 31. The defense is not required to locate exculpatory evidence or potentially useful evidence of third-party suspects. That is the requirement of law enforcement. Law enforcement did not deem them to be suspects. After Richard Allen was arrested, and even before Richard Allen was arrested, there is no evidence that links these men to this crime. None. Odinists, maybe. Bad guys, maybe. But they have no evidence linking them to the crime scene or to Delphi that day. 32. Also, at said May 2nd, 2024 deposition, Brad Holder told a third different story concerning how many times he met victim Abigail Williams, 2 times, and that one of Brad Holder's meetings with Abby Williams took place at Patrick Westfall's house. 33. When Jerry Holman was confronted with Brad Holder's ever-changing stories concerning how many times Brad Holder met Abby Williams, Holman stated, perfectly reasonable in my opinion, that he remembered somebody insignificant. If you've only met them twice, you may not remember that. So I don't see exactly what you're asking me. Holman, deposition, page 4, lines 1 through 15. Emphasis added. 34. When Holman was asked if it were likely that Brad Holder would not remember meeting Abby, when Holder was asked 3 days after the murders at his February 17, 2017 interview, but then 7 years later he would remember meeting Abby twice, Holman responded, possibly, yeah. Holman, deposition, page 4, lines 16 through 21. 35. Holman showed no curiosity nor interest whatsoever about why Holder's stories have changed. This attitude supports an argument which defense will later make in this motion that law enforcement have acted intentionally or in bad faith to conceal evidence to such a degree that they cannot even admit obvious factual inconsistencies that point the finger at third-party suspects. Number 36, Patrick Westfall was interviewed on August 17, 2024, and law enforcement extracted data from Westfall's phone. 37, the phone extraction shows that Westfall's phone had no data prior to August 11th of 2023, which was the day that law enforcement contacted Westfall and asked him to come in to be interviewed 1 week later. 38. In other words, it appears that Patrick Westfall either erased all of the phone data on his phone or purchased a new phone after police contacted him on or about August 11th, 2023. The only data found on Westfall's phone was between August 11th, 2023, on or about when police contacted him, and August 17th, 2023, when he was interviewed. No texts, videos, photographs, email messages, nor any other data existed on Westfall's phone before the day that police contacted Westfall on August 11th, 2023. Wow, how convenient for them to not know that somebody can, turn in and get a new phone. I mean, there could be a lot of explanations as to why there's no data on his phone. It's ridiculous. 39. When Jerry Holman was confronted with the fact that Patrick Holder, which it's not Patrick Holder, again, here is the defense not proofing a document that they send to the court. It's Patrick Westfall, ladies and gentlemen, not Patrick Holder. Likely erased, attempted to hide his phone data from the state police. Holman claimed that he found nothing unusual, stating police erase things all the time, or people erase things all the time. Holman, deposition, page 8, lines 8 through 11. Later, Holman stated that he found nothing suspicious about Patrick Westfall deleting or concealing his phone data before his August 17th, 2017 interview. Holman, deposition, page 9, lines 1 through 3. 40. Again, Holman's attitude toward third-party suspect Patrick Westfall supports the defense's position that law enforcement has intentionally destroyed evidence or acted in bad faith or have intentionally not provided missing evidence, such as Brad Holder's second interview, as well as other items identified in this motion. Again, law enforcement deemed these men were not suspects. There was nothing that made them think that they should have kept or looked at anything. They looked at these men, the FBI looked at these men, and they ruled them out. 41. At his August 30th, 2023 interview, State Trooper David Vito did not even ask Brad Holder if he, Holder, would allow state police to extract data from his phone, even though it is clear that Holder had brought his phone with him to the interview. They didn't want his phone. They don't need to look at him anymore. Good Lord. The only reason they interviewed him in August was because the defense brought up the fact that the interview was lost. I'm sure of that. 42. Therefore, it is not known whether Holder similarly hid, erased data from his phone like it appears Westfall hid or erased data from his phone. Just because it appears to be so doesn't make it so, gentlemen. Just because it appears does not make it fact, does not make it evidence. There's a lot of things that appears to be something that it's not. A lot of times things appear to be something that it's not. 43. It certainly is curious as to why Vito did not request Holder's phone data when Holder brought his phone to the August 30th, 2023 interview. It's not curious at all. He didn't feel the need. He didn't feel it was important. It is also curious as to why Vito failed to ask Brad Holder one single question about Elvis Fields. 45. It is also curious as to why Vito failed to ask Brad Holder one single question as to the incriminating statements that Amber Holder attributed to Brad Holder that are detailed in Frank's 1. Again, hearsay. 46. Vito's failure to ask such important questions to Brad Holder during the August 30th, 2023 interview supports the defense contention that law enforcement is acting in bad faith. Mimicked crime scene image found on Brad Holder's social media is lost. There's many of us that have it. All they have to do is ask for it. I'm sure somebody out there that's supporting Richard Allen's innocence would certainly send that image to them because, believe me, it was downloaded by a ton of people. 47. In addition to Holder's 2017 missing phone extraction and missing evidence of Holder's second interview at the Logansport police station, as well as Holder's taped over first interview from February 17, 2017, another key piece of evidence is also missing: the mimicked crime scene photo that was on Brad Holder's social media pages. 48. Trooper Purdy viewed this mimicked crime scene image on Brad Holder's social media page sometime in the spring of 2017. This image was marked as Exhibit F in Purdy's deposition and discussed on pages 79 to 81. 49. This mimicked crime scene image found on Holder's social media page holds an eerie similarity to the actual crime scene. Trust me, it's what led people on social media to deep dive this guy. These things were weird. Everybody thought so. But this crime scene image that they're talking about was on his social media well before the crime. 50. In the mimicked crime scene image found on Holder's social media page, the bodies of two women appear to be staged lying on the ground in the woods with branches laid across their bodies. 51. One of the women in the mimicked crime scene image found on Brad Holder's social media page has her arms staged, positioned in a similar manner as one of the victim's hands were staged or positioned in this case. I mean, they are reaching, you guys. They are reaching so bad in this document. It's disgusting. But it's what they're supposed to do as defense attorneys, I guess. 52. At the time that Trooper Purdy observed the mimicked crime scene photo on Brad Holder's social media page, the general public did not have knowledge of the appearance of the crime scene, the positioning of the bodies on the ground in the woods, or that branches and sticks were arranged on the bodies. I can guarantee you that many people already had some idea of the positioning of the bodies in this case because of the searchers that found the bodies and the fact that one of the searchers was related to one of the victims. They're crazy. These guys are absolutely off the rails. And they just keep saying the same stuff over and over again. 53. In an April 12, 2017 report from Trooper Ryan Winters, it was learned that the state police also came into possession of said mimicked crime scene image through an internet sleuth named Ryan Butcher. 54. Butcher alerted Winters to the disconcerting images on Brad Holder's social media pages and then sent images to Trooper Winters over the internet. 55. On April 12, 2017, Trooper Winters then shared with Jerry Holman his Winters knowledge of the mimicked crime scene images found on Holder's social media pages and other information. 56. Because of the similarities between the images that Butcher sent Trooper Winters from Brad Holder's social media and the crime scene, Trooper Winters requested that Brad Holder be re-interviewed. Brad Holder was at work and can prove he was at work. 57. Despite that request, state police ignored Trooper Winters and never re-interviewed Brad Holder. Brad Holder was only interviewed in August of 2023 after Jerry Holman was challenged by the defense to reopen the Brad Holder investigation. There is no Brad Holder investigation. Brad Holder was at work. 58. To this day, the prosecution has failed to turn over the mimicked crime scene image that Purdy found on Holder's social media in 2017. They don't deem it as relevant. 59. Fortunately, because internet sleuth Butcher had saved the image that he had turned over to Trooper Winters, the defense team was able to drive to Georgia and retrieve that image. They made a wasted trip. They didn't need to drive to Georgia. There's plenty of internet sleuthers in Indiana that have that image. They just needed to reach out. 60. When deposed, Trooper Winters claimed that the state police could not access the images that Butcher found on Holder's social media that Butcher then turned over to the state police. Winter, deposition August 23rd, 2023, page 29, lines 20 to 23. 61. How could state police lose such an important piece of evidence as an image found on a suspect's social media that mimics the crime scene? He wasn't a suspect. It wasn't something that mimicked the crime scene. You can look at things after the fact and make them appear any way you want them to. 62. The defense again would proffer that the mimicked crime scene photo was not lost. Logic and common sense dictates that such an important piece of evidence would not be lost by state police. Logic and common sense dictates that this defense team is reaching and that they won't give up. The defense is filing simultaneously herewith its memorandum in support of its second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory evidence. 64. As detailed in said memorandum, if the defense can show that the missing evidence is exculpatory in nature, then the defense does not need to show that the missing evidence was intentionally destroyed. 65. If, on the other hand, the defense cannot show that the missing evidence was exculpatory in nature, but can show that the missing evidence is potentially useful evidence, then the motion to dismiss should still be granted if the defense can show that law enforcement intentionally or acted in bad faith regarding the destroyed or missing evidence. Law enforcement did not act in bad faith. They just want the public to believe this because that's the only defense they have. They're not here in a motion talking about trying to explain Bridge Guy and the fact that their client has over 30 confessions to different people about this crime. They're not here trying to explain those away. Why is any of this relevant to Richard Allen and Richard Allen's arrest? 66. Currently, the list of missing evidence that the prosecution has not turned over to the defense includes the following: video of Brad Holder's first interview from February 17th, 2017, video of Logan Holder's interview from February 17th, data from Brad Holder's phone extraction from February 17th, Video from Brad Holder's second interview with law enforcement taken at the Logansport police station sometime in 2017 or 2018. Audio taken from Brad Holder's second interview with law enforcement taken at the Logansport police station sometime in 2017 or 2018. Any reports, notes, or documents concerning or referring to Brad Holder's second interview at the Logansport police station sometime in 2017 or 2018. Mimicked crime scene photo observed by Trooper Purdy on Brad Holder's social media page. Images Ryan Butcher sent to Trooper Winters on April 12, 2017. Again, just because the defense deems this all as evidence does not mean it is. Notice that all missing items are related to third-party suspect Brad Holder. Also note that the prosecution is asking that the defense not be allowed to even mention the name Brad Holder during trial. Absolutely. They have ruined this man's life. He will forever be associated with this case as a potential, possible, quote unquote, suspect person of interest because of them naming him in their actions. 69. Currently, the list of evidence that the prosecution failed to turn over to the defense until the defense requested the prosecution to turn it over, or upon the prosecution realization that the defense would soon be learning about the existence of said evidence, includes Todd Click's letter and accompanying 85-page report. The prosecutor held on to this evidence for over 4 months until he knew the defense would learn of its existence. That has not been proven. Just so you know, none of this has ever been talked about in court yet. This is just them throwing stuff at the wall to see if it's going to stick. Multiple Elvis Field interviews, Rod Abrams interviews, multiple Johnny Messer interviews, multiple Taylor Hornaday interviews, Ned Smith interview, and Libby German's phone dump. Notice all items AG in paragraph 69 above are related to third-party suspects and Odinism. 71. Also, note that the prosecution is asking that the defense not be allowed to even mention any of these third-party suspects or Odinism during the trial. The evidence that the defense does not have in its possession showcases that on multiple occasions, third-party suspect Brad Holder has changed his answer concerning a very basic question. How many times has he met Abigail Williams? Again, just so everyone knows, witnesses tend to forget the longer that they go as time goes on, which is another reason why the defense wants to delay. Now they want to throw the case out. I don't see that happening, but good luck with that. According to the only police report that memorialized Brad Holder's accidentally destroyed first interview, Holder stated that he had never met Abby Williams. And I firmly believe that. I believe that he never did meet her. Why would he have? Abby was not dating Logan. They didn't go anywhere together. Okay? That has never been proven. That is not out there in evidence that they were dating and going places together. They lived in 2 different cities. They went to 2 different schools. Everything that they had was an online relationship. At the time that he was first approached by law enforcement and asked that question, how many times did you meet Abby Williams? Common sense would dictate that the answer would be fresh in Brad Holder's mind and easy to detail because of A, the proximity and the time that Brad Holder's son dated Abby Williams. He did not date her. Logan Holder was dating Abby Williams at the time of the murders. No, he wasn't. There was no dating going on. They were boyfriend and girlfriend, 13-year-old. A 13-year-old. Come on, you guys. Where's their common sense that they like to tout about everybody else? Good Lord. And B, the enormity of the situation. 2 girls had been murdered, one of whom dated Brad Holder's son. 75. If Brad Holder is any way involved in the murders, as the defense believes the evidence strongly supports, then Brad Holder's claim close in time to the murders that he never met Abby Williams is understandable. Denying that he had ever even met Abby Williams could, in Holder's mind at least, cause the police to take their attention off of him. 76. If at his February 17, 2017 interview, Holder was telling the truth that he never met Abby Williams, then his answer to police when he asked the same question, even 6.5 years later on August 30th, should easily be the same: I never met her, because a father would definitely remember if he ever met his son's girlfriend who had been murdered. Conversely, a father would know if he had never met the murdered girlfriend of his son involved in a high-profile case. 77. Again, it is proven that over time, witnesses' memories fade. So this is, I don't believe this for 1 second. It's very possible, especially like I said, since it was a girlfriend, but it wasn't an in-person girlfriend. 77. However, if at his February 2017 interview, Holder was not telling the truth as to how many times he met Abby Williams, then it may be difficult for Holder to remember what lie he told law enforcement 6.5 years earlier when he was re-interviewed on August 30th, 2023. 78. At his August 30th, 2023 interview, Brad Holder's story changed. Now he claimed that, in fact, he had met Abby Williams one time. 79. Either Brad Holder intentionally lied to police in 2017, closer in time to when Logan dated Abby, or Brad Holder had simply forgotten his meeting with Abby, but then somehow remembered that meeting 6.5 years later. 80. Then at this May 2nd, 2024 deposition, Brad Holder provided yet a third different answer. He actually had met Abby Williams 2 times. 81. Furthermore, at his May 2nd, 2023 deposition, was it 2023 or 2024? Come on, you guys, get somebody to please proofread your documents. Holder remembered that one of those meetings occurred at Patrick Westfall's house. Holder deposition, pages 20 to 21. Brad Holder's ever-changing answers to such a simple question provides evidence that the missing items, A through H, detailed in paragraph 66, are exculpatory in nature. No, it doesn't. 83. When combined with the evidence contained on Brad Holder's social media pages, including images of a rune inked onto Holder's hand that mimics the way sticks were formed on Abby's body, as well as all the other evidence detailed in Frank's one, the ever-changing stories of Brad Holder on the simple topic of how many times did you meet Abby Williams should all provide insight into why the defense believes that the missing evidence contained obviously exculpatory evidence. How could it not? You know, it's obvious. I mean, they could say this about a number of different persons of interest in this case, about how things kind of look like them, because stop and think about all the online sleuthing that went on over this 5 years of this case before Richard Allen was arrested, and all the things that people thought made them be evidence against them as being involved in this case. The Kleins come to mind. It would be impossible for the defense to show that the missing evidence contains clearly exculpatory evidence. There you go. Bingo. Contains clearly exculpatory evidence. They can't show that. Therefore, the defense is left with providing circumstantial evidence along with logic, reason, and common sense as to why the many missing items would contain obvious exculpatory evidence. They have to be able to show it's exculpatory. They cannot. Bingo. Done, and done. 85. The defense believes that it has shown that the missing destroyed evidence is exculpatory in nature. No, they have not. They just got done telling you in the previous item, 84, that it would be impossible for them to show that the missing evidence contains clearly exculpatory evidence. And it's not about what you believe. Doug Carter told them that. It's not about what you believe. It's what you can prove, ladies and gentlemen. They can't prove this. There is no way to prove this. The missing destroyed evidence is exculpatory, but even if the court disagrees, the court should find the missing destroyed evidence as potentially useful and dismiss charges. 86. As detailed in the accompanying memorandum, if this court finds that the missing destroyed evidence is not exculpatory but does find that it is potentially useful, then the court should dismiss charges. If it also finds that law enforcement intentionally caused the potentially useful evidence to be destroyed or acted in bad faith, regarding the missing evidence. Franks 1-4 provides many details of why this court should believe that law enforcement intentionally caused the potentially useful evidence detailed herein to be destroyed or acted in bad faith. Franks 1-4 is a joke. 88. The defense incorporates the contents of Franks 1-4 in this motion. Of course they do. Why not go ahead and make a fifth Franks motion inside the motion to dismiss? 89. Provided below are a few facts that support the defense contention that law enforcement has acted in bad faith or intentionally lost or destroyed evidence or have failed to turn over said evidence to the defense. A. Missing portions of vital video from Jerry Holman's 10/26/22 interrogation of Richard Allen. Jerry Holman interrogated Richard Allen on October 26, 2022, and said interrogation was videotaped. However, the first few minutes of the interrogation are inexplicably missing. The missing portions of the video, according to Jerry Holman, would have shown Holman discussing Richard Allen's Miranda rights and freedom to leave the room. Both important concepts that might support the legality or illegality of Holman's interrogation. No explanation exists as to why the only portion of the videotaped interrogation that is missing is the crucial beginning of the interrogation. The missing video supports the defense's contention that Holman knew he had screwed up and therefore edited out the first few minutes of the interrogation to avoid the statement being suppressed. Why do they want the statement to be suppressed, you guys? What did he tell Jerry Holman in that interview that is so important that they suppress that statement? 5. The missing video from Holman's October 26th interrogation of Richard Allen is evidence of intentionality of law enforcement involving the concealment or destruction of evidence and or evidence of bad faith. B. Jerry Holman lied in his October 10th, 2023 deposition that Brad Holder was never a suspect. In his August 10th, 2023 deposition, when asked if Brad Holder was ever a suspect, Holman said the following: "Not really, no." However, it is clear from reviewing emails from Doug Carter and the FBI that Brad Holder was a suspect very early on in the case. A person of interest, perhaps, but not a true suspect. There were lots of persons of interest in the beginning. As stated before, Holder was thought to be a suspect, and his name was known as a suspect even at the highest level of the state police. Superintendent Doug Carter, and even known to Indianapolis's top FBI agent, Jay Abbott. First of all, Jay Abbott was very, very hands-on in this investigation early on, as was Doug Carter. They were getting daily briefings of what was happening with this case. So for them to not know who they were looking at or potential persons of interest, come on. They're expected to know this information. They're making a mountain out of a molehill. The fact that Holman misled the defense by claiming that Holder was not really a suspect is evidence of the intentionality of law enforcement of involving the concealment of evidence and or evidence of bad faith. No, it's not. It's Holman, who is a seasoned law enforcement officer, who deemed that he was not really a suspect. No. The prosecution failed to turn over the Todd Click exculpatory evidence for 4 months, and then only turned it over after it was obvious that the defense would be learning of the existence of the Click letter. As detailed in Franks 1 and numerous other pleadings, beggings, I would call them, the prosecution chose to not turn over exculpatory evidence from May 1st, 2023 until September 8th, 2023 of a letter from Todd Click in 85 pages detailing his investigation. How many times do they have to repeat this in this document? Contained in the Click letter was evidence that 3 law enforcement officers who investigated the case believed that third-party suspects Brad Holder, Patrick Westfall, and Elvis Fields were involved in the murders, and Click's belief that the evidence supporting their involvement in the murders was much more compelling than the evidence against Richard Allen. As stated in a previous, first of all, he didn't know all of the evidence against Richard Allen. I hope not. Why would Click know all the evidence against Richard Allen? He wasn't involved in the investigation. So that's impossible for him to know. As stated in a previous pleading, it is hard to believe that a much stronger example of exculpatory evidence could exist than documentation that 3 law enforcement officers essentially believed that the wrong man may have been arrested. You know, there were a lot of law enforcement officers that believed in the very beginning that Ron Logan was the man on the bridge and that he was responsible for Abby and Libby's murders. And they quickly found out that that was not the case. Just because you believe something doesn't mean you're correct. Just because you believe something, you have to be able to prove it. Can these law enforcement officers prove this? No. It's a feeling they have, a conspiracy feeling. The fact that the prosecution refused to not immediately turn over the exculpatory click letter for over 4 months is evidence of the intentionality of law enforcement involving the concealment of evidence and or evidence of bad faith. D, the prosecution failed to turn over exculpatory evidence contained in several videotape statements until after the prosecution knew that the defense would soon learn of their existence. As detailed earlier in this motion and in Frank's 1, the prosecutor failed to turn over several videotaped interviews that provided exculpatory evidence concerning third-party suspects until after it was clear that the defense would soon be learning of the existence of those videotaped interviews. This is a classic defense tactic here. This is classic. As you know, they have not said anything in this motion about Richard Allen's innocence. Nothing. There is no words in here about their defendant, client, whatever you want to call him to them, because at this point, I'm not even sure that they know what their responsibility is to him. There's nothing in here about Richard Allen's innocence, and that is why the case should be dismissed. Where is all of their documentation that Richard Allen wasn't the man on the bridge, that Richard Allen isn't the man in Libby's video that tells them down the hill and takes them? Where is the evidence? Where is all of this? Richard Allen puts himself there, places himself there, has 30 different confessions of things that he has done. We don't know what those confessions are, but the defense does. The prosecutor turned over these videotaped interviews nearly 9 months later than required under rule and statute. Those videotaped interviews provided exculpatory evidence in terms of blown alibis of third-party suspects, as well as connectivity between third-party suspects and also provable lies told by third-party suspects concerning their knowledge of other third-party suspects. Hearsay is not admissible in court. It's hearsay. And if all they're going on is what Amber Holder is saying, if that's the only evidence that they have, and then Elvis Fields, who happens to be someone who has a mental capacity much younger than the age of 10, I'm sorry, that's not evidence either. They need more than that. The fact that the prosecution failed to turn over exculpatory evidence that supports the involvement of third-party suspects in committing the murders until after the defense would soon learn of their existence is evidence of the intentionality of law enforcement involving the concealment of evidence and or evidence of bad faith. Again, they looked at these men, they looked at all of this stuff, they deemed them not relevant. E, the prosecution and law enforcement attempted to conceal the identity of a Purdue professor whose testimony contradicted the sworn statement of Jerry Holman. Again, Fig Solves debunked this. The Purdue professor did not contradict the sworn statement of Jerry Holman. He did not. In fact, he said the defense misused his statements out of context. This matter has been detailed in Frank's 1, 2, and 3, and in various other pleadings previously filed. Of course it has, because all you do is regurgitate the same crap over and over again in your pleadings. At his August 10th, 2023 deposition, Jerry Holman stated under oath that part of the reason that law enforcement ruled out that persons practicing Odinism or some type of cult had committed the murders was because a Purdue professor had ruled out such a possibility. Holman, August 10th, 2023. However, after reviewing the Purdue professor's report prepared on or about March 1st, 2017, as well as listening to the Purdue professor's September 19th, 2023 interview, it was determined that the Purdue professor never made such a claim as Jerry Holman stated in his deposition. Remember, there has never been in the history of mankind a odinistic cult sacrifice of children of any kind anywhere on this planet, except in the minds of these men representing Richard Allen. Furthermore, at his deposition, the Purdue professor, Jeffrey Turco, specifically denied that he had ever made the very statements that Holman attributed to Turco. Additionally, the prosecution told the defense in a September 6, 2023 email that the identity of the Purdue professor was still unknown and may not ever be able to be found. This was untrue, as Jerry Holman had already learned of Jeffrey Turco's name weeks earlier. Additionally, the defense learned that the actual Purdue report from March 1st, 2017, which also contradicts Holman's testimony, was in the possession of law enforcement since that time, but was purportedly rediscovered by law enforcement in August 2023. The prosecution finally produced said report to the defense on October 4th, 2023, and only upon request of the defense. Jerry Holman's August 10th, 2023 deposition testimony was false concerning the findings of the Purdue professor, and therefore his testimony is evidence of law enforcement's intentionality in attempting to conceal evidence and or evidence of bad faith. The attempt of law enforcement and the prosecutor to conceal the identity of the Purdue professor is further evidence of the intentionality in attempting to conceal evidence and or evidence of bad faith. F. The prosecution failed to turn over one of the key pieces of evidence for nearly 9 months, and then only after the defense kept requesting the prosecution for the same. A key piece of evidence in the case is the phone data extracted from victim Liberty German's phone. The prosecution and law enforcement had possessed that evidence for 5 years prior to Richard Allen's arrest, and therefore should have been able to provide that evidence immediately to the defense. However, the defense did not receive that evidence until September 8th, 2023, almost 9 months later than required under criminal rule. That is not true. But anyway, after the defense had a chance, as far as the criminal rule, after the defense had a chance to review said data from the phone, it was determined that exculpatory evidence existed in the phone that did not support law enforcement's timeline and supports that third-party suspects were involved in the murders. Really? The failure of law enforcement to turn over Liberty German's phone for nearly 9 months, thereby concealing exculpatory evidence the defense could have been explaining from the beginning of their representation, is further evidence of intentionality in attempting to conceal evidence and or evidence of bad faith. Law enforcement concealed the Blocker report until April 26, 2024. On April 26, 2024, the state of Indiana turned over a report from Steve Mullen concerning the findings of Sergeant Mitch Blocker of the Indiana State Police. Contained in the body of that report was exculpatory information concerning ping information that supports that on February 13, 2017, the victims were not located at the same scene as they were found on February 14, 2017. So all I can tell you here is that they do not understand ping information, and that is not true. That is not true, and there's no evidence that supports this. The failure of the law enforcement in turning over this report for well over 1 year beyond when the prosecution was required to turn it over, and only after the defense sent a certified letter and filed a motion to compel and for sanctions demanding that the prosecutor turn over certain evidence, is further evidence of intentionality in attempting to conceal evidence and or evidence of bad faith. Tobe Lesenby contradicted the sworn testimony of both Jerry Holman and Tony Liggett concerning the number of people involved in the murders. This matter is detailed in Franks 1. Both Liggett and Holman testified under oath that only one person, Richard Allen, was involved in the murder of the victims. This proclamation under oath by Liggett and Holman would negate the defense's contention that the evidence supports that multiple people involved in Odinism were involved in the murders. However, when Tobe Lesenby was deposed, he stated under oath that Tony Liggett actually believed that multiple people were involved in the murders. This conflicting sworn testimony of law enforcement is further evidence of intentionality on the part of law enforcement to conceal their actual beliefs concerning the number of people involved in the murders of the victims in order to direct the defense away from the theories that Odenists were involved in the murders, and additionally is evidence of bad faith. No recordings of Richard Allen's interview with Dan Doolin exists. In 2017, Dan Doolin has stated that Doolin, knew that he had audio recorded interviews when conducting interviews of tips and leads. The Doolin deposition, page 55, lines 18 to 25. Doolin claims that he now believes that he never audio recorded his interview of Richard Allen. I think I must not have audio recorded it because all the other ones that I had are in a file on my computer, and I listened to each of them just in case they were mislabeled. Every audio recording I have, and none of them was Mr. Allen. Doolin deposition, page 56, lines 2 through 9. This interview is crucial as what Doolin claims Allen told him helped establish the timeline used to secure a search warrant and to arrest Allen. The defense believes that Richard Allen was tape recorded and that the missing tape supports intentionally on the part of law enforcement and or evidence of bad faith. Missing mimicked crime scene image. This was detailed earlier in this motion and in Frank's one. So why are you going over it again? Good Lord. 90. Brad Holder is a key third-party suspect, yet Jerry Holman denied that fact, and then law enforcement failed to turn over multiple pieces of evidence that support Holder's involvement, along with other third-party suspects identified in Frank's one. 91. Furthermore, law enforcement have claimed that Brad Holder's initial interview was taped over. 92. Furthermore, law enforcement claims apparently that they never extracted data from Brad Holder's phone when they extracted data from at least 101 other phones from people who weren't even suspects like Holder. 93. Furthermore, law enforcement claim apparently that they never extracted data from Brad Holder's phone when they extracted data from Logan Holder's phone, which was turned over to the police at the exact time that Holder turned over his phone. 94. Furthermore, law enforcement has turned over zero evidence of Brad Holder's second interview conducted at the Logansport police station, and the defense only learned of said interview through a deposition of Brad Holder conducted on May 2nd, 2024. Then go to the Logansport police station and ask them for it, as Jerry Holman told you to. Furthermore, law enforcement claim that they cannot access the mimicked crime scene photo that was on Brad Holder's social media page. 96. All of the issues of missing evidence surround one person, Brad Holder, and Odenism, which the prosecution is also attempting to block the defense from even mentioning at trial. Richard Allen cannot have a fair trial when exculpatory evidence that would support the involvement of third-party suspects is missing. Only so many coincidences can explain away why so much evidence concerning Brad Holder and Odenism is still missing, and why the prosecution failed to turn over much of the evidence that the defense does in fact possess concerning third-party suspects for 9 months or more, and only after the prosecution knew that the defense would soon be learning of the existence of that third-party suspect evidence. 99. The bad faith of law enforcement and the prosecution has been proven through these numerous examples of missing evidence and evidence that the prosecution failed to turn over to the defense in a timely manner. 100. Because the missing evidence is exculpatory in nature, the charges against Richard Allen should be dismissed. It's not exculpatory in nature. They even said they can't state that it's exculpatory in nature. They can't prove that. Even if the court finds that the missing evidence is not exculpatory, it is clearly potentially useful evidence, and the numerous examples of bad faith contained in this motion require that charges against Richard Allen be dismissed. Wherefore, pursuant to the law detailed in his memorandum in support of this motion, as well as the facts contained in this motion, the defense requests this court to dismiss all charges against Richard Allen. Respectfully submitted, Andrew Baldwin. Good luck with that. What a complete and utter joke, you guys. Seriously. I mean, it was enough to get through that and to read all of it, but I felt that it was important. I tried to bring up some counter measures, but my God, this is, yes, the defense has to do everything they can to get their client off, but there has to be a point where we say, where is the justice for Abby and Libby? How much more of this circus do we have to contend with? These guys claim they want a speedy trial, first of all. They wanted a speedy trial. Now they're trying to get the case thrown out because They don't have a case. They have no defense of Richard Allen at this point, and they know that. They know that his 30-some confessions are going to be his downfall, and they are going to be what convicts him. And all I can say is my heart goes out to the families of Abigail Williams and Liberty German. I know that this has to be hell on earth for them. If I'm this blown up and excitable by this crap that the defense keeps doing, I can only imagine what this circus and merry-go-round of court dates and then canceled court dates and trial dates and then rescheduled dates is doing to them. But I will remind everyone that Paul Holes told everyone at CrimeCon a year or two ago, this is exactly what the defense in this country is allowed to do. This is exactly how cases happen. And for people who do not follow cases closely, this seems to be completely out of the norm, but it's not. Defense attorneys do this every single day, and they motion and motion and motion the court to death. And by doing so, and asking for continuances and delays and delays and delays, it can take years for these cases to actually make it to trial. And that is a benefit to the defense the longer they keep this out of court, even though on the surface, they're trying to tell everyone, oh, we want a speedy trial. No, they don't. And anybody who can't see that, I ask you, where is the common sense? Where's the logic? I'm going to use their words against them. Thanks for watching, everybody. Have a great night or a great day. And I will see you all tonight at 8 p.m. Central Standard Time. And Steve from True Crime Web will be my guest. Good night, everybody.